Alright guys, welcome back to the channel. For today's video, we're going to be finally putting to bed this idea of driving versus traveling and whether or not the US Constitution makes it illegal for states and local municipalities to require driver's license registration and restrict people's ability to drive a motor vehicle without those documents. I've made a video about this once before and I did it slightly differently. Today we're going to be doing like an all-encompassing no, you people are stupid because you can't read and you're lying about what the Supreme Court cases say. That's what today's video is going to be about. The video that I made once before was where I just took an isolated case and I wanted to kind of debunk what people were saying about that case, because I've got one of these driving versus traveling web pages up right here. And when you go down through, you will inevitably see this case of Thompson versus Smith. And then you'll also see, if you only read the letters in bold, which is what they want to do, the right to travel upon public highways or automobile is not merely a privilege, but is a common right. The common right of the people to travel about the country. That is something that is guaranteed by the Constitution. But what the Constitution is guaranteeing is that basically states cannot prohibit member or residents of other states from crossing state lines. That's what this right to travel throughout the United States is. It actually has nothing to do with driving a motor vehicle. And people always quote this Thompson versus Smith. There's actually a lot of cases that say the right to travel is guaranteed. But what I did in that particular video, which we're just going to do a very quick rehashing because this video might reach out to people that have not seen that one before. This is the actual transcript from Thompson versus Smith. And in that particular case, we had a police chief. His name was Smith, and I believe this was in Lynchburg, Virginia. It's been a while since I looked at the entire text of this. But the police chief of Lynchburg, Virginia, had a man that was driving through his city. He had issued this man multiple traffic citations and decided that he was going to revoke this person's license because he was deemed unfit to drive, because the city of Lynchburg, Tennessee had an ordinance that said the chief of police may basically take away your driver's license if he deems you unfit to drive. The problem with that law was it did not list any specific criteria that would allow the chief of police to restrict your driving privileges. It was basically, and what did they say here? It is basically arbitrary. And that is what was discussed in this case. As I talked about the case, there is never in question, never a doubt anywhere in Thompson versus Smith whether or not the state of Virginia has the authority to require people to have a driver's license. Thompson versus Smith is about whether or not the police chief was allowed to take away your driving privileges based on his own personal beliefs that you're an unsafe driver. And I highlighted a paragraph from the case here, and that's what I'm going to read now, and then we're going to move on. And this is what this actual case was about. That portion of the ordinance here in question, which authorizes the chief of police to revoke the permit of any driver who, in his opinion, becomes unfit to drive an automobile on the streets of the city, fails to declare the policy of law and fix the legal principles which are to control the discretion of the chief of police in the revocation of licenses, in determining what constitutes unfitness to drive an automobile on the streets of his city, is void because it delegates powers essentially legislative to an administrative office. So what it's saying is basically you have an arbitrary idea and there's too much discretion in the law here. Therefore, since there's too much discretion, we are going to strike down this law. Now, there's some other things on this particular page that I will get to in a moment, but I think the easiest way to do this is actually to point to a Supreme Court case. This is a U.S. Supreme Court case that actually upholds the authority of states to issue driver's licenses to another states, upholds the authority of a state to issue a driver's license to individuals or require individuals to have a driver's license. And this is really clear-cut wording from the Supreme Court of the United States that kind of explains this. This is Hendricks versus Maryland. This is 1915 case. And this is a case where this guy named Hendrick, he lived in Washington, D.C. if you don't know much about the United States, we have 50 states, and then we also have Washington, D.C., which is its own place. It's not a state, it's just its own weird place. So he was saying, I live in Washington, D.C., and I traveled into Maryland, and then I was stopped for not having proper registration on my vehicle. Since I am not a resident of the state of Maryland, they cannot hold me to the standard because I am not a resident of that state. The whole the Confederation of States of the United States and how they have like equal rule over themselves, or at least a portion of it. It's a little bit more convoluted than that, but you kind of understand. In the United States, different states have different rules. He was saying, listen, I live in Washington, D.C. I can't be held to rules that are put in place in Maryland. What the Supreme Court actually held was, what? It's true. What they looked at was, does this law in Maryland unfairly restrict the ability of people who live in Washington, D.C.? And it's actually in the paragraph above this. I don't have it highlighted because I don't want to, this whole paragraph isn't that important, but it does say that the record fails to disclose if Hendricks complied with the laws in force in the District of Columbia respecting registration of motor vehicles. So the Supreme Court actually says, what? If you're a resident of Washington, D.C., and they have a registration law, you're required to follow that law, which would have also made you in compliance with the law in Maryland. But this paragraph right here is the most important paragraph of the entire case, and that's what I'm going to read for you now. It says, the movement of motor vehicles over the highways is attended by a constant and serious dangers to the public, and is abnormally destructive to the roadways themselves. Their success depends on good roads and construction and maintenance of which are exceedingly expensive. In recent years, insistent demands have been placed upon the roads for better facilities, especially in the ever-increasing number of those who own these vehicles. I'm not going to go ahead and read this entire thing, but what the Supreme Court says, you can read it for yourself, is that, roads are expensive to build. They're expensive, they're complex, this, that, and the other thing. And they're also, motor vehicles are dangerous to operate. Since roads and everything are expensive and motor vehicles are dangerous, the Supreme Court has ruled, states can, surely that's common sense. They have the authority to regulate these kinds of things. The registration fees and all that, those go to help build all the roads and everything that your motor vehicle is going to use, and your license ensures that you're a safe person when you're using those roads. And then the next paragraph here is something I like to highlight as well, and it says, in the absence of national legislation covering the subject, a state may rightfully prescribe uniform regulations for public safety in order to respect the operation upon its highways of motor vehicles, those moving in interstate commerce as well as others. This is another important point that a lot of people like to bring up. And I think that's where we're going to go back to this Nutjob's webpage right here. This is that guy that's like, the right to drive, the right to travel throughout the United States cannot be limited based on the Constitution of the United States. It doesn't matter if you're traveling in a motor vehicle, if you're not traveling in a motor vehicle, it doesn't matter. And then they'll go down and they'll pull up these definitions. And they'll say, according to U.S. Code Title 18, Section 319-6, so definition of motor vehicle says a bunch of blah, blah, blah for commercial purposes. And then they'll say the definition of commercial purposes, considered directly upon or indirectly with any business for undertaking of profit. And then they'll say, listen, the United States Constitution says a motor vehicle is only considered a motor vehicle if you're getting paid to drive it. That's not true. The other thing that you have to remember is that there is no national law regarding a driver's license. This is something that the federal government has left up to the states. Just like this, in the absence of national legislation covering the subject, any state may rightfully prescribe uniform regulations necessary for public safety. That's why states are allowed to have driver's licensing laws. And these titles or these definitions as defined under U.S. Code are irrelevant. the only reason that these title or these definitions would be relevant is if there was actually a national standard driver's license and registration fee. If there was a national driver's license and we wrote all of our driver's license tickets based on a national code, we would then have to adhere to these definitions. I also am willing to absolutely guarantee without a shadow of a doubt that if there was a national driver's license law, they would go ahead and change this definition. Definitions are something that can change freely, if that makes any sense to anybody. But since the regulation of roads and highways are left up to the states, because it's up to the states to determine what is safe for them, the definitions in the U.S. code are completely irrelevant. And then the only time that commerce does come into play here is that the federal government has used the Commerce Clause, saying, you know, this is interstate commerce. People need to be able to drive from one state to another, and we expect the laws from one state to another to be relatively uniform. And if, say, let's say Ohio set its speed limit on the highway at 25 miles an hour, and Indiana had its speed on the highway set at 85 miles an hour. And then there was a bunch of state troopers sitting right at the border of Ohio and Indiana, writing people for going 60 miles an hour over the speed limit. The federal government would come in and say, listen, you can't do that. Like, these laws and regulations, they have to be somewhat uniform. This is an interstate commerce issue. We're going to strike down your law, making that unconstitutional. It has to be at least somewhat similar to the law next door. It doesn't have to be the same, but it has to be somewhat similar. That would be where interstate commerce would come into play. So the U.S. Supreme Court has ruled on driver's licenses, has said that states are allowed to issue driver's licenses, and said that the reasons for driver's license and registration laws is for safety and to raise money in order to build those roads and everything, right? So that is where all of that stands. Now, here's another thing that's going to happen when these people who believe that you don't need to have a driver's license, they believe that the U.S. Constitution forbids states from requiring driver's license and all that other stuff. What they do is they all go to like the same web page and they all copy and paste the same cases. I've got a comment right here from my previous video on driver's licenses, and this person, Ashled whatever 63 or 6703, made a whole bunch of lists here. And what they do is they will take a Supreme Court case and they will pretend that it applies to the subject at hand when it doesn't. What they're doing is they're trying to mislead you. They're actually lying. They're lying about what the case was actually about. And then they will take one line from the case and actually try to say that that's what the case was about, or try to say that that applies to all cases across the United States. Sometimes, in some cases, they're actually not even quoting lines from the actual case. So what we're going to do now is we're going to go through all of these cases and show you why these people are being foolish. So the first one, they're going to use Chicago Coach versus the city of Chicago. And the line that they chose is no state government or entity has the power to allow or deny passages on the highways, byways, waterways, transportation, and his vehicles, properties, or either recreational business without being by being subject only to local regulations. Safety, traffic lights, blah, blah, blah. Travel is not merely a privilege requiring a license of a vehicle registration and forced insurance. So let's go to Chicago Chicago Coach Company versus the city of Chicago and try to determine what the issue was in this case. This particular case is one where Chicago Motor Coach Company already had a license to operate as a business in the state of Chicago. And the city of Chicago tried to say, look, you might have a state license, but I'm going to require you to have a local license as well because you are traveling through my city. This went to the state Supreme Court, the Supreme Court of Illinois, and the Supreme Court said, listen, Chicago, you're playing games. You can't do this. This business already has a license to operate in the state, and the state has supremacy over your city ordinances. Therefore, you cannot fine them for not having a local city license. And this is about business licensing. This isn't about having a license to drive a vehicle. That's a case where they're lying about what the case was about in order to try to make it fit their goofy narrative. The next one, people versus battle. Traffic infractions are not a crime. Let's see. Sorry, wrong page. People versus battle. This is a case where this guy battle. He was driving a motor vehicle and it had bad brakes. What year was this? 1975. The bad brakes caused him to lose control and hit, and I believe he killed somebody. Either killed somebody or seriously injured somebody. The police officer that arrived on scene issued him a citation for an equipment violation. So he had to pay a $50 fine plus a $15 penalty. He went ahead and pled guilty to that. And then several months later, there was an investigation that occurred from the point of the accident to a later date when he was charged with a felony count of, I don't remember what the count was. It was like a aggravated vehicular homicide or reckless homicide or reckless assault, something like that. But it was a felony. The state charged him with a felony, and his argument was, listen, I was already issued a citation for this accident. I paid my misdemeanor fine. Therefore, you can't charge me again for the same crime because that would be double jeopardy. The court went through all of this stuff, and one of the arguments was whether or not traffic infractions were crimes as compared to a felony and blah, blah, blah. I'm not going to read through the entire decision right now. I read through this entire case already. What the Supreme Court said was, well, the law for the state of Illinois was already written before they added their traffic code. When they added the traffic code, they chose to use the word infraction, but what they really meant was crime. And in this case, if you actually read what the justices said, they said, for all intents and purposes, a traffic infraction is a crime because it can be, you could be put in jail and all this other stuff for it. So then the question becomes, is this equipment violation of driving with bad brakes, is that a lesser included offense of a vehicular assault? And they determined that this was not actually double jeopardy because he pled guilty to an equipment offense, but he was being charged with the offense of driving his vehicle in a way that hurt somebody. The equipment offense was part of that, but it wasn't the entirety of it. So they allowed this to go on. They said, no, it's not double jeopardy. The next one. Let's see. So this one's funny. Shuttlesworth, and I'm trying to go fast because I'm already 18 minutes. Shuttlesworth versus Birmingham. A person is faced with an unconstitutional licensing law which purports to require a license as a prerequisite to exercise a right, a bunch of blah, blah, blah. I've got the case right here. This is in 1968. This is in the heat of the civil rights movement. This is Birmingham, Alabama. And this was a bunch of African-American protesters that wanted to hold a march. I can't remember the absolute details of it, but the city of Birmingham said, you know what, you can't protest without a permit. We require permits to have a protest. Therefore, we're going to arrest a whole bunch of you. This actually went all the way to the Supreme Court. The Supreme Court ruled, no, protesting is a First Amendment activity, and you cannot require a permit in order to take advantage of your First Amendment. This has nothing to do with driving. What they're trying to say, where's that picture? What they're trying to say by saying it's unconstitutional to require a license for something that is the existent exercise of a right, they're trying to say, well, listen, I have the right to travel. You can't require me to have a license to travel. Therefore, the Supreme Court has already ruled on this. Well, no, the right to travel in a motor vehicle is not the same as your right to travel between the states. That is what the Supreme Court has said. So it's silly that they do that. City of Chicago versus Collins. Those who gave the right to do something cannot be licensed for something they already have the right to do, which would be meaningless. They're trying to make the same argument as above. This is another case of, this is actually a taxation case. And this is the city of Chicago once again being shifty and trying to tax the same items multiple times. And they're trying to say, well, you have to register your vehicle in the state because, we need that tax revenue to build roads and everything. But also, if you're going to drive your vehicle in the city of Chicago, we're also going to require you to register that vehicle in the city of Chicago because you're using our roads. This was struck down by the Supreme Court of Illinois. The other thing is that when people say that their license laws are unconstitutional in the United States, they're bringing up a lot of these like local cases that have nothing to do with the U.S. Supreme Court. And they like to pick and choose what when the Supreme Court is right and when the Supreme Court is wrong. Often they'll choose cases from the 1800s that are just completely inapplicable or have been overridden by now, but that's a separate issue. Let's see. Wingfield versus Felder. Court makes it clear that a license relates to qualifications to engage in a profession, business, trade, thus merely traveling without compensation for profit outside of a business entrepreneur. Okay, so Wingfield versus Felder. I have that one right here. This is not a case about traveling or whatever, because one of the arguments people often make is, yes, the government can require you to have a license because driving is unsafe. And then they'll also say, do you think that you should be allowed to travel in an airplane without a license? And these goofballs will bring up Wingfield versus Felder, and they pull out one tiny little part of that says, you can't require a license for qualifications and blah, blah, blah. And they throw in the word commerce and all the other stuff. This case has nothing to do with whether or not the state can issue someone a pilot's license. I don't even know if pilot's licenses are issued by the state. They might be issued by the federal government. I would think the FAA would have something to do with that. But regardless, that's not what this case is about. This particular case is actually about a guy who was a crop duster. He flew a plane and sprayed chemicals on crops. There was somebody that worked for the Department of Agriculture. It's highlighted right here. And they went out and they watched him flying around, and they said, we don't like the way he's flying. He is flying unsafe. We're going to revoke his pilot's license. And they tried to do that, and it went to the Supreme Court of California, and the Supreme Court of California said, no, the Department of Agriculture does not have the authority to remove this guy's pilot's license. It had nothing to do with your right to travel and no license required and all that other stuff. Let's see. Some of these are really horrible. With regard to, Donley versus Union Sewer Pipe. With regard particular to the U.S. Constitution, it's elementary, the right or protected that documents cannot be overthrown or impaired by any state police authority. I don't even know if I pulled that case up. I did. This has to do with like writing checks and when you can cash them and all the other stuff. That has nothing to do with driving. When these people come out and they make these arguments, they're not being honest. They're being foolish. At the end of the day, the U.S. Supreme Court has upheld states' authorities to issue driver's license and require registration. That has been done and granted on the federal level. It also says, where is it? It says for commerce or otherwise. Oh, shoot. I lost my spot in here, but it's in there. Read the case for yourself. And the other thing that I want to point out, I just want to remind everybody that there is no U.S. national law requiring driver's licenses. Therefore, these titles that are in the U.S. code and these definitions in the U.S. code, they are irrelevant to your discussion when you're talking about the state of Ohio and whether or not the state of Ohio has the authority to require you to have a driver's license, or the state of Indiana or California or Texas or whatever. Since there's no federal law about them, the states get to do that. That's, I forget the constitutional explanation for that, but it's there. And it was also mentioned in Hendricks. There was something else I was going to say about this, but I can't quite remember, and I don't think it really matters. The fact of the matter is you do need a driver's license in the United States because every state has laws regarding driver's licenses. Those laws do not violate the Constitution of the United States. Your ability to travel is guaranteed to you, but if you're going to do it in a motor vehicle, you have to have a driver's license. I think I'm going in circles. Thanks for watching. I'll talk to you later.